I've been doing estate planning since the 80s, and one of the things I've really seen a lot of is the growth of superannuation and self-managed super funds. And I've been concerned that people spend a lot of time with their wills, their cascading powers of attorneys, their three-generational testamentary trusts. But what about this superannuation? Where does it go at death? Well, it can only go to two places, either to dependents, such as your children, your husband, your wife, or to your estate, your legal personal representative. They're the only two places it can go to. But one of the problems is there's nothing tight, nothing concrete about guaranteeing that the money gets put into the right location. So let's have a look at some of the things you can do. You've got a super fund. Let's say it's a self-managed super fund. You can do nothing, in which case the trustees or the remaining trustees after you die will make the decision where the superannuation will go. If I'm your trustee, I'm going to surely try and find a way to make sure it comes to me, even though that may not be your wishes. You can do a nomination. It's not binding. The remaining trustees may consider it, they may not consider it. You can do a binding nomination, and that lasts for 3 years. Then you can freshen it up if you've still got, if you're still of sound mind. Not sure a power of attorney can allow you to freshen it up. That's another story. A binding nomination is a very good way to remove the discretion from the trustee into your hands, and then you can make a decision whether you want your superannuation, your death benefit ETP, going directly to dependents or into the will and then be dealt with according to your will. A third way is to type into your trust deed a non-binding, non-lapsing nomination, and they never go out of date. You can get Alzheimer's disease, live for another 20 years, and the nomination will still be binding on the trustees. It takes their discretion away. Now, in the case of Mr. Munro, who is a Queensland lawyer who died, the courts considered just recently Mr. Munro's binding nomination. It was a lapsing binding nomination, so it expires after 3 years, but he made one and he died within a 2-year period. So it was still operational as far as that was concerned. However, he made a little bit of a mistake. He copied the wording from that an accountant had prepared, and then his financial advisor had prepared the wording, and then he just merely copied the wording. And instead of leaving it to one of two locations, he used wording which was not correct. So what the wording that he should have used is peculiar to a member's dependents or to the legal person representative. He used the wording to trustee of a deceased estate. Don't know where he got that wording from. It just didn't work. The trustee of the self-managed super fund, she looked at it, that was his second wife, looked at it and said, well, this is not binding. She appointed one of her own children to the trust so that the self-managed super fund had two trustees, as it needs to have, or it needs to have a corporate trustee. She chose to have a second person. And they made the decision, acting in the best interests of the self-managed super fund, with no recourse to the Supreme Court reconsidering it. They made the decision that the second wife would get all the superannuation, which was a huge amount of money compared with the rest of the estate. The two daughters, Mr. Munro's two daughters, were furious with that. So they went off to the Supreme Court and said, it's a binding nomination. It's within the 3-year period. It's quite clear the money's to go to the estate, and therefore it goes to us because we're named as the beneficiaries in the estate. Unfortunately, the law deals with what's legal, not what ought to have been done. So, sadly for Mr. Munro, may have well turned in his grave. The super ended up staying in the self-managed super fund to be dealt with by the trustees of the self-managed super fund trustees. What should have been done? Well, firstly, you need to deal with, just because you're a lawyer doesn't mean that you can deal with superannuation. Just because you're an advisor or accountant doesn't mean you deal with superannuation. There's specialist areas. Now, putting aside the fact there should have been a non-lapsing binding nomination, it should have been correctly drafted, we also at Legal Consolidated use a number of other approaches to make sure that there is a guarantee that the daughters in the situation would not be left out, and that would be by inserting a corporate trustee. We call this an intergenerational corporate trustee structure, and how it operates is that upon Mr. Munro's death, there's a corporate trustee, and he leaves his share in the corporate company, which is the trustee of the Self-Managed Super Fund. He leaves that right, that ownership, to his daughters, so that if the binding nomination fails for whatever reason, the laws change, who knows, the girls have a seat on the table to be able to negotiate what is going to happen with the superannuation. There are many tricks to making sure the super gets into the estate or to the dependents. Now, if you're going to leave it to the estate, consider putting in place a superannuation testamentary trust. If you've done a will with my old law firm, Brett Davies Lawyers, or with my new law firm, Legal Consolidated, you will have a superannuation testamentary trust. And this means that only if the super, the death benefit ETP, goes into the estate, then the non-dependency taxes, the taxation of the superannuation, can generally be washed out if you can find people out of a huge group of family members that will be paying tax at a lesser tax rate because they're dependents under the tax legislation. So enjoy your superannuation, but be aware that there are repercussions if you don't draft things rightly in your estate planning. Enjoy.